Hi everyone, welcome to COV-AID Conversations with a Lawyer. I'm Esther, and together with me I have Austin, and we will be the moderators for today's session. Today we are extremely privileged to have Jessie and her legal associate Tanya from JHT Law Corporation to talk to us about COVID's impact on real estate law in Singapore and what legal reliefs have been introduced in this area which can help both landlords and tenants out. Jessie is currently an executive director of JHT Law Corporation, a law firm based in Singapore. She read law at the University of Cambridge, where she obtained both her bachelor's degree and her master's, and was subsequently called to the Singapore Bar in Singapore. Today, Jessie has accumulated a wealth of experience in her 30 years of practice and primarily advises on conveyancing and litigation matters. She's currently also on the board of directors of Halogen Foundation, a non-profit organization that focuses on youth leadership and entrepreneurship. Hi Jessie, now that the viewers know more about you, maybe you can start with a small introductory question to help them better understand the landscape in these COVID times. Could you please tell us what the most interesting COVID-related case that you have worked on recently is?
Well, I think there have been so many cases, but I think the one that stands out in my memory would possibly be a case of a very, very anxious landlord having a tenant that had owed him rental for quite some time. I mean, I don't think the market was terribly great even before COVID started, but COVID just made it 10 times worse. So right in the midst of the pandemic, I had urgent, frantic call from him saying that his tenant has not been paying rent for, of course, the months during the circuit breaker and prior to that. What were his proposed course of action that he could take? Now, everyone had been bandying about this concept, said the moratorium, you can't sue your tenant. But what had happened was that the tenant had broken the lease already by leaving the premises, and the outstanding rental was rental in relation to rent that had occurred before the COVID Relief Act had kicked in, which was before February 2020. Under those circumstances, we advised the client that it was possible for them to pursue the claim. So I can just remember very vividly the client calling me in a sheer panic, sheer anger, sheer frustration. So these are one of the many, many incidents that we've had over this period of time.
Oh yeah, truly COVID has been a very stressful and unprecedented time for everyone. In your opinion then, do you think landlords or tenants have been hit harder by COVID?
Actually, for my line of practice, where we do a lot of conveyancing, so a lot of my clients would be landlord investors. So I see more of the landlord's pain and the woes because they're expecting to receive rental investment income. But on the other hand, we also get a lot of fair bit of tenants coming in to say, look, my landlord's not passing me on the rent. What are my reliefs? I'm going out of business. So a fair bit of that, but more from the landlord side. That's just the function of my work at the moment. Anecdotally, I can tell you since August, which is when the government released the full details of the COVID relief, one of which says that the tenants have to prove that they qualify for additional relief. They have to swear a statutory declaration. And arising out of the fact that I'm also a commissioner of oath, I do see a steady trickle of people coming in to swear that simple statutory declaration so that they can send it to the landlords. So there you are.
Yeah. You mentioned briefly about the COVID relief. We can probably just jump straight in.
Yes.
That's probably what the viewers are most interested about. So I've heard about this COVID-19 Temporary Measures Act 2020 that was rolled out. What exactly is this and how can this help landlords and tenants out?
Okay, so let me just go through with you some of the details. This Rental Relief Temporary Measures Act was introduced in April 2020. It provides for parties to a scheduled contract, a contract defined as defined in there, a temporary relief from their contractual obligations. Now, let me emphasize, it is only a temporary relief, okay? It's a prohibition against enforcing the contractual obligations. This includes leases and license of non-residential immovable property. I emphasize that because a lot of people will come and ask me, I am now currently staying, I have a residential lease in a penthouse. I've lost my job. Can I get any relief out of this? No. The answer is because the COVID Temporary Measures Act only covers and only relates to commercial properties.
So in that case, not residential owners cannot obtain any relief under this act.
Unfortunately, no.
What is the
Only
relevant
commercial
period?
properties.
Mhm.
Okay.
Commercial
The
property.
relevant period for this would be for the period 1st of February 2020 to the 19th of October 2020. But there is a little a caveat to that. The lease or license agreement should have been entered into prior March 25th, 2020. So that's very important. The period of validity is from the period 1st of February 2020 to 19th of October, provided that the lease or license was entered into before 25th March 2020.
How about late payment interest under this act? Does it continue to accrue?
Okay, so that's a good question, Esther. There are two tranches that tenants need to bear in mind. Tenants or landlord. Landlords want to levy the late payment, and tenants have to be the ones paying it. So there are two tranches. The late payment and interest charges between February 2020 and the 19th of October 2020 is capped at a maximum of 5% per annum. Now, guys, very important for me to kind of explain that in a lot of tenancy agreements, some of them like to use punitive, almost punitive rates. So they will say 6%, 7%. So those go out of the window during this rental relief period. It is capped at 5% between 1st February 2020 and 19th of October 2020. You hear me repeating this because there is a separate cap for a different period, because if the amount that the tenant is able to defer, they get a deferment period up to next year. During that deferment period, the interest rate is capped at 3%. So it's very important to distinguish the two time zones.
I think we'll be talking more about the repayment repayment scheme
Correct.
later on
That
in
is
the interview. So we'll jump back into that. But for now, we have another question on how does the relief apply? Does it apply automatically? What do landlords or tenants have to do?
No. So guys, it's very important for any layperson, any tenant listening to this, for them to realize that it does not apply automatically. The tenant has to submit a notification for relief in a prescribed form. This is found in the MinLaw website. So the individual will have to sign in using a court pass, SingPass, sorry. The individual signs in using the SingPass and the company signs in using the court pass. It is a form that will be submitted online. So it is an opt-in, guys. They have to take advantage and submit the application.
Just to underscore that point, it does not apply automatically. There needs to be an application for this relief to apply. So maybe we can move on into the details of this, the nitty-gritties. So Jessie, could you tell us more about how this rental relief framework works, which was introduced in June 2020?
Correct. So, good. I'm waiting for the rental relief scheme to flash up. Good. So this additional rental relief was provided to SME tenants who were affected by the COVID-19. This illustration that I hope comes up on the share screen will show to you the qualifying period. So the rental waiver provided will be effectively April and May for qualifying commercial properties. If there is another subsection called the additional rental relief, which will apply for the months June and July. So that will add up to a total of 4 months for qualifying commercial properties. With respect to industrial and office premises such as my office, the maximum will be 1 month plus an additional 1 month, leading to a total of 2 months rental relief. So you have to section yourself. Are you a commercial, shop, retail, or are you an office, industrial premises? So that will demarcate your amount of relief. So there is the first band, which is the one that's called just the rental relief. And then there is the additional band called the additional rental relief, ARR.
I see. So who qualifies for the first band under A, rental relief for SMEs? Who qualifies for this section?
That's right. Okay. So the first band of just the rental relief, that will be for an SME with an SME being defined as with no more than 100 million annual turnover. So if you exceed that, you have a happy problem. You do not qualify for these rental relief. All right. So that's the first thing, and that is for which year? For which year is it? It's for year assessment 2019, right? For YA 2018 reported. Okay, so that is for the first. Now, perhaps shall we go into that letter? This, I wanted to bring up an example of this rental relief, guys, to you. I will screen share a typical letter that the government has sent. It's just a sample with redacted key information. Perhaps this is the time to go dive deep into this information for you guys. If you look at the letter, it will talk about the cash grant and rental waiver, the rental relief program. If you see this is a standard wording, for instance, in this instant case, the landlord only obtained a cash grant of 2,309.33. And it came out to be a formula of 0.64 of the annual value. I've highlighted the words in yellow so that you can track it. Now, it's very, very important for landlords listening in to understand the concept that they are required under these current rules to give to the tenants the full rental rebate of the contractual rent. Contractual meaning what is stated on your tenancy agreement. But unfortunately, herein lies the gap. If you look at the government's letter, they explain to you the rental waiver that's given back to you, the cash rebate, is not equal to the sum of the property tax rebate and government cash grant that has been given back to you. So pause, let me explain that again. The amount of cash grant and the property tax rebate that is given to landlords is computed based on the annual value of the property. In textbooks, annual value is described or used as a formula to compute the likely rental that a property will generate if it had been leased out. So that's the definition of annual value. So herein, this is a very realistic problem. The cash grant that goes back to landlords is different and maybe less than the contractual rent that they are actually charging to the tenants.
I see. So the government doesn't give the total loss that landlords might suffer in this pandemic.
Yes, unfortunately, that is the way. But you can understand, possibly they needed an arbiter, a very non-contentious method of assessing how much to give back, and therefore they just used the open disclosed barometer, which is the annual value, for assessment purposes.
Sure. So that relates to the first band, right, of rental relief for SMEs that's supported by the government. How about the second band, which is an additional rental relief that's up to 2 months?
Okay, good. So a lot of the tenants would be squawking at this time and going, gosh, that's not enough for me. I'm still suffering. My business hasn't recovered. In those cases, if you're still the first qualifying SME with a turnover of no more than 100 million in revenue, and you can prove, so it's an and, so first qualifying is 100 million turnover and less, and you have suffered a 35% drop in your revenue for the period, it is a limited period, April to May 2020, compared versus to April and May 2019, then you can apply and qualify for the second band of additional rental relief. To trigger that, you have to submit to your landlords a begging letter, probably, and also accompanied by your statutory declarations, which is what I referred to earlier.
I see. So this entire rental relief scheme can last up to 4 months for qualifying commercial properties, but it's not a guaranteed 4 months. There needs to be separate qualifications for both bands.
That is correct. It is an application. So tenants have to work hard to get it as well. All right.
So how exactly is this rental relief going to be affected?
Okay, very good. Good question. So you remember just now I flashed up on the screen a sample letter. Literally, that is what triggers the rental relief. So I think in early August, many of us landlords received the love letter from IRAS, the sample, which is, I hope is coming up on print screen. So this letter is very, very important because it actually says, what is your dollar value? There are also actions that the landlords have to take. The landlords are required under the prescription in the letter to extend a copy to the tenant. If there is a subtenant, to ensure that it is also passed down to the subtenant down the food chain. This is important because then everyone adjusts their expectations accordingly because they know the dollar value of the grant. There is no room for suspicion. There is no room for saying, a landlord saying, well, I received less, and he tries to pocket some of this, for instance. The letter is there, it says very clearly, it cuts down a dispute as much as possible. So the amount of dollar value that the landlords get is stated on the letter, and it is also stated in the IRAS letter. It is the duty and function of the landlord to forward this letter to the tenant or end user tenant. So it makes it very clear and very easy to navigate. All right. So the landlords, remember when I said that there is an obligation to show it to the tenant, it has actually stated it is to be sent to the tenants within 4 working days. So a lot of the issues would have been sorted by now because we're already in September.
So practically speaking, most of these formalities might already have been carried out.
Yes, unless the post has been very late, the letters have not been received, but I think anecdotally, most of my clients have received it. So about 95% have received it.
Sure. So maybe since the formalities have been carried out, then landlords will be most concerned about how exactly are they going to get the money from the government. So where does this rental relief come from?
Okay, so the rental relief is, again, this is wonderful Singapore style. The monies will be downloaded into the landlord's bank accounts. And you can say, how did the Big Brother know it? But yes, Big Brother do know your bank account numbers. So it'll be just sent to the landlord's bank accounts directly by IRAS. So again, this is wonderful Singapore at its best. Everything is super efficient.
Wow.
Yeah.
Big Brother Singapore.
Exactly.
How about, are landlords able to maybe effect their rental relief through installments or in parts if they decide not to give the full relief at once? Can they do so in differing times to their tenants?
Yes. So landlords are definitely able to kind of spread out the pain. Can you imagine that if it was a landlord investor who's also waiting upon the rental to pay his expenses, it would be too much of a pain to earn zero for a certain month. It is for the landlord and the tenant to come to an agreement, and they can certainly effect the rental relief through an installment arrangement. So perhaps every month I give you a discount of $500. So the tenant continues to pay, but perhaps pay at a lesser band. So certainly it is possible. There is no restriction in the IRAS rules or under the Act that they must follow a certain set formula.
Well, it does seem like there's some kind of flexibility for landlords and tenants to work around here.
Yes,
how
exactly.
about if a landlord has passed on a rebate to an earlier tenant that doesn't cover the period from April to July? What happens then?
In those circumstances, then the landlord can use, so the credit has already been granted and it was made way more than the relief, whatever. The landlord can use the same to offset the future months rental to the subsequent eligible tenant. So that is what can be passed on.
And what happens then in the case that a tenant has already paid for the waiver period? Can the landlord say, I'm not gonna?
Oh, no.
Yeah.
Again, remember the IRAS letters are very fierce and it is a legal obligation. The rent payable by the tenant for the renewing period shall be reduced by the prescribed waiver amount. Then what the landlords cannot do in this circumstance is to hold on to the rental relief and pocket it. it must be passed down. This is a measure to support businesses, and therefore it must go down the food chain accordingly. The landlords cannot sit on it. That is very, very clear. And if, say, the tenant has already paid the rent during time and the tenancy is at an end, there are no longer any months of rental that the landlord can effect deductions or rental waivers on, then it is the duty of the landlord to refund the monies, refund to the tenant, to the applicable tenant. Yeah?
I see. So again, we see quite a lot of flexibility here, just that not flexibility to the extent that the landlord can sit on the money and pocket it for themselves.
Exactly. It's a pro-business initiative.
Yeah. Thank you for the great explanation on the rental relief scheme. So now Austin will be talking more about the repayment scheme and asking Jessie about that.
Yeah, so we've talked a bit about the flexibilities afforded to landlords. Now, regarding tenants and their repayment schemes available to them, what if, let's say, the tenant needs more time to repay arrears accumulated from 1st February to 19th October?
Now, so this, for the listeners, this is very important. It's different from what we were talking about just now. In the earlier sections, we were talking about rental relief. We were talking about additional rental relief. Right now, what we're talking about is rentals that could not be paid during the lockdown, during the COVID, because there was a moratorium on enforcement on outstanding rentals. So if the tenant needs more time to pay, he can elect it. Now, this again is very important. It is triggered by the tenant making and serving an application to the landlord. And listen to this, is double asterisk time. Take out your yellow highlighter to mark out this part of the tuition lesson. The notice to the landlord must be served no later than 19th of October. So remember this, guys, if you need time to pay your outstanding rental and arrears, you have to submit to the landlords an application before 19th of October 2020. Key date, 19th of October 2020.
I see. So after we have submitted, we as the tenants have submitted the notice onto the landlord. What exactly is this prescribed repayment scheme?
So the accumulated arrears, now the accumulated arrears cannot exceed 5 months, okay, for commercial properties. So offices, shops, restaurants, you cannot say exceed more than 5 months. For industrial and commercial properties, the amount of accumulated arrears should not exceed 4 months. So 5, 4. 5 for commercial, retail, shops, etc. Industrial and office properties, maximum of 4 months. So first distinction, submit the application before 19th of October, and then the period that it can be extended to, this arrears accumulated either 5 months or 4 months, can be extended for a period of up to 9 months. So the accumulated can be stretched for a further period of 9 months. And the first installments to your landlord must be paid starting from 1st of November. So your 9 months must start by 1st of November.
Right. And is there interest payable during this repayment scheme?
Exactly. So earlier on my tuition lesson, I had talked about the amount that the landlords can charge the poor tenants. So during this extended period of 9 months of paying, this extended lifeline to give them time to pay off their arrears, the interest in this scheme is capped at 3%. 3%.
Right.
So it is a bit of pain, but it takes into account the pain of the landlords as well, because if they have outstanding rental owed to them, they also need to recover some interest to compensate. So it's a kind of agreement. It's a kind of just a touch, a soft touch that they
it's to make it fair to landlords as well, essentially.
Exactly. It is a bit of a pain for the tenant, but surely they also have to understand that landlords bear a bit of a pain. So it's a kind of the sweet spot, you would say.
So what happens in the event which the tenant defaults in payment under the repayment scheme, or if, say, the lease or license is terminated?
Okay, so this is important. Remember, conceptually, the idea behind these schemes are to encourage businesses to stay on, to keep afloat, right, for both parties. Therefore, and it requires some honorability on both sides. Now, if the tenant therefore defaults, doesn't want to pay, or he defaults in this lifeline that's given to him, then the repayment scheme will be cancelled. So let me explain. So remember I said that your repayment scheme will start from 1st of November, and then you are duty bound to pay it in 9 equal installments. And then in the first month, you already default in this rent that you already owe for so many months. In such a case, the entire scheme will collapse, and all the amount that you owe to the landlords will become accelerated and payable immediately. And then in such a case, there's no more moratorium. The landlord can take any steps that they need to take to recover the outstanding rent. So this is very important for tenants who have a serious business and want to continue and make good use of this extended rental repayment period to honor their contractual obligations during this time. It helps them, it helps the landlords to plan as well.
So essentially, tenants shouldn't abuse this, and they should seek to honor their original agreements.
Yes, because it helps both the landlords and tenants.
Right. So we've talked a lot about relief schemes available for tenants. Let's talk about some relief schemes available for landlords. Going back to the additional rent relief schemes for tenants, what happens in the event that the landlord himself is unable to afford the additional rental relief?
Okay, so this is a realistic problem. Of course, you know, in Singapore, there are lots of landlords who are just living off their rental income as well. So to trigger the rental relief scheme, landlord, for landlords, the landlord should be an individual and sole proprietor. Okay, I emphasize this because if you are a commercial company, a private limited investment holding company, this relief will not be available to you. So it is for the individual landlord or the sole proprietor landlord. There is also a limitation. The landlords will get a rental relief if the aggregate annual value, remember I spoke about the concept of the annual value. The annual value of all the investment properties owned by the landlord is not more than 60,000 as at 30th of April 2020. So this again allows an assessment of what sort of landlord are you. If your property exceeds 60,000, that is just the arbitrary cutoff point that your property is worth so much more, you probably have that much more wealth accumulated, etc., and therefore the rental relief will not apply to you. Don't ask me why the rule is there. I'm just explaining that that is the rule. Okay, so individual, number one, an individual or sole proprietor, and the annual value of the property. The annual value of the property should not exceed 60,000. And then the third one to trigger it, remember there are 3 limbs to this. The rental income derived from the property should constitute 75% or more of the landlord's gross income. That means 3/4 of your income is derived from rental investments of the commercial property. And in such an event, you can go and ask for the relief to give this tenant the additional rental relief, the ARR, the second band. Remember?
Right. So how can the landlord himself verify their tenant's eligibility for the rental relief?
So in order, the landlords should ask the tenants to provide the eligibility by way of this document called the Statutory Declaration, which I referred to. The tenant occupier will swear on oath. So that means you cannot fib, no fibbing about this, because it's a declaration under oath that says I meet the criteria for rental waiver, i.e. I'm a company that has a turnover of under 100 million, and my company has suffered a massive drop of under the 35% drop in and that is what triggers it. So they will ask the tenant to provide that information.
Right. Yeah. Next, so we've talked about small landlords, but are there additional relief measures available for individual landlords with existing loan commitments? So for instance, if you took out a mortgage to purchase this investment property and are renting this out.
Okay, so this is a very good, interesting, and very real life thing. So a lot of, what do investment landlords do? They put the seed money down, the deposit to pay for the property. They take a loan to help service the purchase, to pay for the purchase price. The rental income goes to pay for the loan to the bank. That is a realistic and very everyday dynamic of how these rental propositions work. So what happens in the situation of COVID? The tenant is not paying me, but I still have my bank behind me insisting on payments. So the landlords are caught in a massive logjam, isn't it? Tenants are not paying downstream, banks are asking for payments. So under the COVID-19 amendment bill, landlords who are individual landlords, again, emphasized, individual landlords, and who are already current, so you're not already a defaulting tenant, you can apply to your bank to defer. Similarly, as much as your tenant is not paying you, you can defer your obligations to the bank as well. You can defer both the principal and interest payment of your loan obligations to your bank for the period up to 31st December 2020. Guys, so this is under, and this is under the regulation right now. So you can go to your bank and apply for the sort of a deferment of the same. It's also stated in the rules that a lot of people are worried that if I ask the bank for deferment, that means I'm not technically paying my bank, my principal and interest. Would I get into a bad credit record? The rules say that this should not affect the credit scores for this period only. In all other cases, if you do not pay your bank on time, it will affect the credit rating, except in this period.
So this applies to individual landlords with existing loan commitments, but are there relief measures available for SME landlords with existing loan commitments as well?
Yes, so landlords who are SMEs can apply to defer the principal payments on their commercial and industrial property loans. They can also, and if they are in need for funds, they can also apply for some credit under this ESG temporary bridging loan programs or working capital loan grants with that several banks have run out already. So there is also a kind of release valve for SME and small SME landlord owners.
Right. So essentially the relief measures help investment landlords survive by providing them extra credit for with regards to their loan payments to banks.
Correct. Correct.
So lastly on this topic, how exactly can landlords apply for these relief measures to the banks?
Okay, so to trigger it, banks love documentation. They need to show to them that they're not just giving these money out easily, and etc. So a couple of key documents that you will need to support. Remember the IRAS letter giving you the notice of the cash grant? That was the first document that you need to produce to your bank. That sets the parameters of how much your annual value is for the property. So that's a very easy document that banks can refer to, and they do not have to do further checks to see whether the information you gave is true and correct, because that document originated from IRAS, who has incontrovertible evidence of the annual value of the property. So notice of the cash grant, the relevant tenancy or lease agreement, of course, because that sets out your contractual rent that you'll be earning, and a declaration of the relief to be provided to their tenants. So that is what you need to declare to the bank. You say, look, I'm required to pass this on to my tenant, and I have done this. And so now I need an application. I need a short-term bridging loan just to tide me over this period.
Right. One last question, Jessie, and this is with regards to Singaporean married couples, and it involves additional buyer's stamp duty remission. So is there an extension of the 6 months remission under the temporary COVID relief measures?
Okay, so let me just explain very quickly so that we can segue the questions. Previously, we've always been talking about commercial rentals and industrial properties, office rentals. This question is a little bit unique, which is a great question. Factually and realistically, a lot of Singaporean couples are affected because they're buying their home, right? And under the IRAS rules, if you haven't sold your first property and you go out and buy a second property, married couples are given a remission period of 6 months to offload their first property. But during the circuit breaker, there was no showing of houses, everyone was locked down. What is the effect? The clock on them still runs. So under the COVID scheme, there is a very intelligent understanding and acceptance of the fact that the 6 months remission period has to be extended. So what I want to explain is that under these relief measures, the married couples will have an addition of 6 months to offload their first property without having to pay ABSD. So there are a couple of limbs to trigger this relief. Let me just go through it very quickly. The couple's second residential property should have been jointly purchased on or before June 2020. So anyone trying to get benefit of this relief now is not going to be able to avail of it, seeing that we're already in September. The second property should have been purchased before June 2020. And prior to the 6 month extension under this temporary relief, the specified timeline should have expired before 1st of February 2020. They got it? So I'll just repeat that again, just for the benefit. Prior to the 6 month extension under this temporary relief measure, the specified timeline, the last date by which the couple should have sold their first property, should have expired on or after 1st February 2020. That means the key date, 1st February 2020. Remember, we had the lockdown almost quite soon after that. So if their remission period would have expired during that time, they get an extension.
Right. So thank you for the most interesting and informative tuition session, Ms. Jessie.
I hope I was able to explain and not going too fast.
You're pretty clear. So that's all the time we have today, and see you next time.
See you next time, Austin. Thank you.
Thank you so much, Jessie.